The 60s was, activism, social responsibility. And the 80s was the glitter of wealth and spending a lot of money. His aim in life was to get rich and famous by doing good.
He wanted to make a name for himself. And he made that clear to us from the beginning. That was one of his intentions.
Schlickman's law partner viewed Woburn much differently.
It was just too difficult a case, too hard a case, too expensive a case, too long a case, too complex. It was a black hole right from the very beginning.
Reluctantly, Schlickman agreed. He drove out to Trinity Episcopal Church, ready to tell the 8 families who had signed on to the lawsuit that he just couldn't take their case.
These were people who inspired you. These were people who it was difficult to say no to. These were people who were very determined to get answers, and their determination was inspiring to us.
The next day he came, and he said, Kevin, I looked into their eyes, and I just couldn't tell them no.
Infused with Schlickman's infectious energy, the lawyers plunged into Woburn. Their lives would never be the same. The first step for Schlickman and his colleagues was finding someone to sue.
Okay.
Working from studies done by the Environmental Protection Agency, they identified the 2 most likely sources of the dangerous contamination. One was a company a half-mile from the wells called Cryovac, which made machines to shrink-wrap food. Cryovac was a division of the chemical giant W.R. Grace. The other was the John J. Riley Tannery. Across the Aberjona River and 700 feet from the wells, it was owned by the Chicago-based conglomerate Beatrice Foods. On May 14th, 1982, Schlickman filed a lawsuit on behalf of the Woburn families against both Grace and Beatrice. The complaint alleged that these 2 companies had contaminated the wells with toxic chemicals, causing leukemia and other illnesses in the East Woburn families. The plaintiff sought damages for the devastation they believe had resulted.
Next week, I need to go into the hospital and get a bone arrow. And if it says it's okay, I can get near some kids, I think, and play with them. And if it isn't okay, I'll have to get the IV again and sleep overnight.
Their contamination of G&H wells contributed to the death of these children, to their sickness, to their illness, to their suffering, and to their final death.
I'd just like to ask them if they'd like to have that water pumped into their house and feed it to their children and their grandchildren.
Beatrice and Grace were both Fortune 500 companies. They had what lawyers like to call deep pockets.
These were 2 very powerful companies, obviously 2 companies with the assets that if in fact they were held accountable, certainly they would be able to pay any kind of judgment, no matter how big it would be under those circumstances. That certainly was attractive in knowing that.
Especially to a personal injury law firm like Schlickman's. Such firms put up the money to pursue a case. In return, they take around 1/3 of any settlement or jury award their clients receive. Woburn, Schlickman knew, could make him a rich man. But companies with deep pockets to settle a case also have deep pockets to fight it. Both Grace and Beatrice were armed with lawyers from 2 of Boston's most powerful firms. It was Grace's counsel who fired the first shot with an aggressive motion to get the case dismissed.
And that motion basically says that this is a frivolous lawsuit. It shouldn't be brought, and the person who brought it should be sanctioned.
I was simply trying to present to the court the question of whether this was a case that ought to be in the court at all.
It was a message, a very clear message to us, that you will proceed at your peril professionally, that this is not just winning or losing a case, this is winning or losing a career. This was war, not litigation.
Federal District Court Judge Walter Skinner rejected Grace's motion, but the bitter tone of the court battle had been established. Adversaries had become enemies in what was already shaping up to be a landmark case.
It was a case that the world, to some extent, was watching. And when the world is watching, you care how it turns out. So I think right from the beginning, there not only was a certain nastiness among the attorneys, but there also was more than your normal will to win.
Beatrice attorney Jerome Fasher knew the case presented exceptional problems for the other side. But Fasher also realized that if the story of Jimmy Anderson and the other Woburn children ever came before a jury, anything could happen.
The possibilities that juries could be influenced by sympathy or anger or other extraneous considerations is always something that a trial lawyer thinks about.
At the very first deposition in the case, it became clear just how powerful the family's testimony would be.
Tears are coming into my eyes just as I think back to that deposition, because all Richard did in his own matter-of-fact way was describe the death of his child. And there was nothing more powerful than a father describing the death of his child.
Richard O'Fierro's son, Jared, was diagnosed with leukemia in June 1982. His status seemed stable until one weekend in September, when Richard and his wife, Lauren, grew alarmed at their son's sluggish condition. The clinic at Boston Children's Hospital told the O'Fierros not to worry, that they should just bring Jared in the following Monday.
And that morning I got up, she's real sick. I called the hospital, and they were real kind of nonchalant about it. Of course, which is, you know, in a way now you think about it's kind of understandable because you have so many parents and everything's an emergency.
He just started a new dose of chemo that Friday.
Everything's an emergency in life, so, but it turned out it wasn't an emergency.
The O'Fierros bundled their son into the car and sped down I-93 toward Boston. On the way, Jared stopped breathing. Desperate, Richard pulled over and tried to revive him. It was too late. As trucks roared by on the highway, Jared died in his father's arms. He was 3 years old. For the families to win in court, their lawyers would have to prove two things: that chemicals from Grace and Beatrice got into the East Woburn water supply, and that these chemicals caused the family's illnesses. But every expert, every test, and every exhibit needed to construct such a complicated case cost money. Money the young firm of Schlickman, Conway, and Crowley quickly realized it didn't have.
This was a contingency fee case. We get paid if we won. And if we didn't win, we didn't get paid.
To raise the millions needed to make their case, the partners had to guarantee bank loans by putting up their own homes. With so much at stake, for the firm, for the families, and for the defense, the case had become all-consuming.
It was the most exhausting, grueling, overwhelming experience that I have ever had and ever hoped to have in my life.
We couldn't lose. We couldn't lose. We had to do everything in our power to win, or else we would not be able to live with ourselves the rest of our lives.
Woburn, as Kevin Conway warned it would, had become a black hole. The vast majority of personal injury lawsuits are settled before they go to trial. But the passions and publicity surrounding the Woburn case made such compromise impossible. For Jan Schlickman and his partners, the case had become a crusade which they became convinced was worth as much as $1 billion. That's next here on 1986. The Woburn, Massachusetts leukemia case had become a war of attrition. Tempers flared as 100-hour work weeks pushed lawyers from both sides to the brink of exhaustion.
You had no other life but this case. It absorbed every part of you, like a war does. It absorbed every part of your waking and sleeping moment and all of your energies.
The little firm of Schlickman, Conway, and Crowley had ballooned to 18 people, soldiers in the battle against Beatrice and Grace, the companies they believed had poisoned their clients' water supply. The two polluted wells had been closed for over 6 years when Woburn officials dismantled them in 1986. But if the wells were gone, the mystery of their contamination remained. From the start, Grace seemed the more vulnerable of the two defendants. Since 1960, the company's Cryovac plant had purchased at least 4 drums of TCE, the toxic chemical found in the wells. EPA officials uncovered 6 more drums buried in a ditch behind the plant. Empty and corroded, they had once held TCE and other toxic solvents. But while Jan Schlickman and the Woburn families had evidence that Grace had both used and dumped TCE, no Grace employee would admit to knowing exactly how the waste was disposed. At first, Al Love's deposition seemed like every other. Love was the receiving clerk at the plant, where he had worked since 1961.
During the first part of his deposition, we got no information from whatsoever. None whatsoever.
After a short break, the attorneys returned with a more personal line of questioning.
And so Jan went in and said, now, Mr. Love, you live in East Woburn too, don't you? You're a neighbor of the plaintiffs in this case. Do you have any health concerns about the contaminated water? And the attorneys jumped up and, you can't answer those questions, and it's irrelevant, and how dare you insult him, and that's the most ridiculous question we've ever heard. Don't answer it. And he didn't answer it, and we left.
But Love was concerned about the water, and his lawyer's objections troubled him.
He got a headache, and the headache didn't go away until he, a week later, walked across the street to Ann Anderson's house and said, look, there's a lot of things that I know that I think, you should know.
He said, I have children too, and I see you and I see your kids, and he said, I can't go on not saying anything any longer. And I picked up the phone and called Jan.
Risking his job, Love met with Schlickman the next night. He described in detail what he saw as Cryovac's careless handling of chemical waste. For years, he confessed, it had been standard practice to dump TCE and other solvents on the ground behind the plant.
He wasn't going to protect somebody or something that he thought was wrong.
Love's revelations broke open the case against W.R. Grace. But with the trial quickly approaching, the plaintiffs had found no such smoking gun to use against the other defendant, Beatrice.
We didn't have an Al Love in Beatrice's case. We had nobody admitting to dumping. All we had was a contaminated site. So the question was who contaminated it and when.
The plaintiffs focused on 15 acres of undeveloped land owned by Beatrice's John J. Riley tannery. They videotaped one of their experts touring the property to show how it had been used for years as a dumping ground.
We have some fragments of drum lids here at our feet. Another rusted out, decomposed drum.
Piles of debris and clumps of what appeared to be sludge from the tannery littered the property. Tests revealed extremely toxic concentrations of TCE in the soil and in well water taken from the site.
Groundwater samples taken